Some lawyers walk into court thinking they're the smartest person in the room until reality hits hard.
Under Illinois versus Allen, I've warned him repeatedly. He's being removed from the courtroom.
From jaw-dropping shutdowns to humiliating legal blunders, here are the most unforgettable moments where idiot lawyers got exactly what they deserved, instantly.
Don't get brazen with me.
Let's start with one of the most controversial trials of Kyle Rittenhouse, who fatally shot Joseph Rosenbaum and Anthony Huber and injured Gage Grosskreutz and ended up in court facing serious charges. But beyond the courtroom drama, this case sparked intense debate about race and privilege.
You indicated that at no time did this gun, this AR-15, ever leave the state of Wisconsin. Is that right?
Other than the night after, other than that.
Before the shootings?
Correct.
There was a time, though, where you wanted to have it with you down in Illinois, isn't it? It wasn't there?
I believe there was a time when me and Dominic were mad at each other. Yeah.
You were mad at Dominic?
Me and Dominic were mad over something.
And you wanted to have the gun with you down there?
I think I said something along those lines.
You have testified to this jury that you used deadly force against Joseph Rosenbaum, Anthony Huber, the man who attempted to kick you in the face, and Gage Grosskreutz on the night of August 25th, correct?
Yes.
And you did that because you felt that your life was in danger from those four people, correct?
Yes.
And you are telling this jury that it was, in your mind, justified to use deadly force to protect your own life, correct?
Yes.
You'd agree with me that you were not allowed to use deadly force to protect that CarSource building, correct?
Well, I wasn't using deadly force to protect the property. I used deadly force to protect myself, so.
Please listen to my question and answer my question if you can. You'd agree with me that you were not allowed to use deadly force to protect that CarSource building, correct?
Yes.
You'd agree with me that you were not allowed to use deadly force to stop someone from smashing the windows of an unoccupied parked car, correct?
I don't think you could use deadly force for that.
You'd agree with me that you can't use deadly force to stop someone from lighting a metal dumpster on fire. You'd agree with me that you can't use deadly force to stop someone who is about to start an unoccupied car on fire, correct?
Tensions hit a boiling point when prosecutor Thomas Binger tried to pull a fast one, claiming the judge approved his line of questioning. Spoiler alert, he didn't. The judge's face said it all, and within seconds he dismissed the jury.
Mr. Binger is either forgetting the court's rulings or attempting to provoke a mistrial in this matter. He knows he can't go into this, and he's asking the questions. I asked the court to strongly admonish him, and the next time it happens, I'll be asking for a mistrial with prejudice.
This was the subject of a motion. I'm well aware of that. And the court left the door open.
For me, not for you. I did. I granted.
We did not move to reconsider.
That was their motion.
We have not filed any motions to reconsider in this case.
That was their motion for reconsideration, which I denied. But I said I denied it, or I indicated a bias towards denial is what I did. Held it open with a bias towards denial. Why would you think that that made it okay for you, without any advance notice, to bring this matter before the jury? I was astonished when you began your examination by commenting on the defendant's post-arrest silence. That's basic law. It's been basic law in this country for 40 years, 50 years. I have no idea why you would do something like that. And it gives, well, I'll leave it at that. So I don't know what you're up to.
May I respond?
Yes.
We filed an other acts motion on this exact issue because, in my mind, and I argued this, it is identical to what was going on the night of August 25th, in the sense that the defendant was using this exact same weapon. He was using it in a manner to try and protect property.
No, he wasn't.
Your Honor, with all due respect...
I'm not going to rehash the motion. That's absolutely untrue. No. Your arguments of record My comments are of record, and why I ruled as I did is of record. There's nothing that I heard in this trial to suggest anything's changed. Even if you're correct in your assumption that you know more than I did at the time, you should have come to the court and say, I want to go into this. Why you would think that you could go into it without any advance notice to the court, I don't understand that. And as the defense is pointing out, you're an experienced trial lawyer, and this should not have been gone into.
Your Honor, there have been things in this case, testimony in this case, that I believe opens the door to this. For example, the defense has introduced evidence that the defendant pointed a gun at a man wearing yellow pants because that person was on a car on the car source lot. Now, there's no justification that I can.
What followed? A verbal smackdown so fiery it could have melted the courtroom walls. Binger's tactics didn't just backfire, they poured gasoline on an already explosive trial.
That's what he
Exactly.
testified.
So he's agreeing. May I finish, please? I'd like to have a chance to make a record if I could, without being interrupted, if that's okay. He has mentioned that he's acknowledged that he's used this gun to protect property. He's also just acknowledged that he knows he can't do that. I am attempting to impeach him now with the prior August 10th incident, 15 days prior, involving the same gun, where he is threatening to use that gun to protect property. It goes.
He didn't have the gun with him.
Your Honor, he is saying he wished he did so he could shoot people.
You know, there's a lot of difference between commenting about something when you haven't got a gun and threatening someone when you do.
You know, it's interesting, Your Honor, because the entire defense theory in this case is Joseph Rosenbaum, who was
I
unarmed.
want you to tell me what the defense theory of the case is. I want.
May I respond
look.
to what you just said, Your Honor? I'd like to respond to what you just said.
Slow down, please.
I apologize, Madam Court Reporter, but I'd like to try and make a record without anyone interrupting me, if that's okay.
Now, I've admitted that kind of evidence in other trials when it's been appropriate. I didn't admit it in this case because, to me, what I've heard in this trial, and by the way, Mr. Richards absolutely correctly points out that just hours ago, I said I had heard nothing in this trial to change any of my rulings. So why?
Testimony, Your Honor.
Pardon me?
That was before the defense
Don't
testimony.
get brazen with me. You knew very well. You know very well that an attorney can't go into these types of areas when the judge has already ruled without asking outside the presence of the jury to do so. So don't give me that. That's number one. Number two, this is propensity evidence. I said at the time that I made my ruling, and I'll repeat again now for you, and it isn't coming in, no matter what you think. Number two, I have to be concerned that with what Mr. Richards has said about the progress of the trial, and when you were I said you were over the line, close to or over the line on commenting on the defendant's pretrial silence, which is a well-known rule. I'm astonished that would have been an issue. So I don't want to have another issue as long as this case continues. Is that clear?
It is.
Thank you. Ask the jury to come back in, please.
Despite the rising tension, Binger managed to keep his cool under pressure, calmly stating that he had in fact filed an other acts motion to support his line of questioning. But Judge Schroeder wasn't having it. He blew up at the prosecutor in front of the courtroom.
No, you're not going to, not to create some alternate universe scenario without something in the record.
Moving on, things got heated in New Jersey when Judge Stephen Taylor took defense attorney Edward Belinkas to task. With the jury out of the room, the judge didn't hold back scolding Belinkas over his aggressive and inappropriate questioning of shooting victim Lauren Kanarek.
What's the nature of your objection, Mr. Shellhorn?
Judge, I think there was a question there suggesting that the attack, the dog bite, and I think there was something else was going on before any shots were fired.
Yeah, I don't even know what the I don't even know what the factual basis is for that.
Judge, I can ask a witness.
No, you can't. No, you can't. Not without a factual basis. You just can't ask for speculation. That's what you're asking for.
I'm asking you a question whether or not.
There's no evidence that it happened before. None.
Judge,
Not a scintilla
I believe
of evidence on the record so far
So
that
if the
supports that question.
If a witness says that something happened, I can't ask them if...
You've asked them 500 questions about what happened, about her recollection of it, which is fine. Now you're asking, well, are you sure it didn't happen before? You have no basis to ask that.
Her recollection is horrible.
No, it's not.
She's changed her story over and over.
It doesn't matter. It doesn't, Mr. Belinkis, it does not allow you to suggest to this jury to engage in speculation, which is what you're doing. Your client doesn't remember the incident, according to the expert reports. So that's not a factual basis for you.
Judge,
and there's nothing in this record to suggest that any of this happened, the beating, the phone, the dog bite, before. In fact, we have a 911 call where it's patently obvious that the dog is in the area because it is incessantly barking and heard over the 911 call, which is after the shooting. So you need a factual basis. That is black letter law 101.
My factual basis, Judge, is that these people, both Cataract and Goodwin, have a motive to lie with regards to what happened. They filed a lawsuit. There's hostility.
But again, even assuming all that's true,
so why?
There's no evidence in the record. That's like saying, well, isn't it true that a stranger drove down the road when Michael Barrasone was there and got out of his car, and the stranger was the one that actually shot you, not Mr. Barrasone? That's the same situation. There's no evidence in the record that that happened.
That defense attorney is skating dangerously close to a contempt of court charge, and honestly, it's kind of impressive how bold he's being. This courtroom is heating up fast, and the line between strategy and sabotage is getting real blurry.
You're just you're trying to create in the jury's mind some alternate issue without any facts in the record to support it. Now, if Mr. Barrasone were going to testify about something, that's different. But the experts have said he doesn't remember anything about the incident.
Understood, Judge, but again, whatever ruling you make, obviously, I abide by. But in this particular case, this witness's testimony, as well as her boyfriend, which are basically the only two pieces of evidence.
No, and the 911 call,
Okay.
which lays out exactly what happened immediately after the shooting.
Immediately after the shooting, and I believe I can question the timing of the shooting based on their inconsistent statement, their motivation to lie.
No, you're not going to, not to create some alternate universe scenario without something in the record.
Well, I can't get anything in the record, Judge, unless I could ask these questions.
No, there's plenty in the record so far. There's plenty in the record so far, but nothing in the record to show that the beating, the dog bite, and everything happened before the shooting.
Well, Mr. Goodwin is going to testify, Judge, that Mrs. Cataract disappeared for a significant period of time.
All right, well then ask him that. Ask him that question.
It's implausible for someone to be shot.
Mr. Belinkis, I can't predict what's going to go on the record in the future when other witnesses testify. If the scenario changes, then you can ask it then. At this point in time, there's nothing in the record to suggest the scenario that you want to ask in a question for the jurors. There's not.
Judge, okay.
That's my ruling. End of it. All right. Go off the record now because you have to...
In court, you're supposed to stick to the facts, not dive into hypotheticals like you're pitching a movie plot, and this defense attorney really missed the mark on this one, but the judge's face said it all. This wasn't the drama he signed up for, so he left.
I honestly have never experienced a level of unprofessionalism.
Next up, Judge Elizabeth Scherer snapped at the Parkland shooters defense team after they abruptly rested their case without warning. What followed was a fiery exchange you'll want to see for yourself. Let's just say, surprising a judge like that, not the wisest move.
Are you going to be questioning the witness?
No, ma'am, but I understand what you're saying.
Oh, why are you standing here? To help me because okay, who's questioning this witness? Hello? Which witness? Your next witness. These don't have anything to do with it.
Yeah, we're just entering them.
These are just records. We're just doing it now.
So is it a secret who's going to be questioning your next witness? Because I'm going to find out in like 3 minutes. Who was doing it?
The records don't relate, but if we call the witness, it will be me. I'm assuming you're talking about that.
Who is your next witness, and when are they being called, and which attorney is going to question them? Let me be clear, if I wasn't before. Because if these don't have anything to do with your next witness, then why are we having the jury wait outside right now?
Just because we were trying to move everything in, because in terms of timing, we do it now.
In terms of timing, it would be much better to do it during the lunch break, when the jury needs longer than you all. So we'll go ahead and pass on this. Let's bring the jury in, please.
Your Honor?
Yes?
At this time, the defense rests, other than putting in our records.
We're not playing chess. I mean, will you please take the jury back in? Thank you. All right, go ahead and put in your records.
2B, Nicholas Cruz Henderson, episode 1 record.
Let me just stop. State, are you going to have anything ready for today?
No. We're expecting,
there was 80 witnesses.
we're waiting for 40 more witnesses.
I just want to say, this is the most uncalled for, unprofessional way to try a case. You all knew about this, and even if you didn't make your decision until this morning, to have 22 people plus all of this staff and every attorney march into court, be waiting as if it's some kind of game. Now I have to send them home. The state's not ready. They're not going to have a witness ready. We have another day wasted. I honestly have never experienced a level of unprofessionalism in my career. It's unbelievable.
So, Judge, if we had any pretrial matters, you asked us to be here at 9:15. We were here at 9:15 to discuss pretrial matters. I have been practicing in this county for 22 years.
You know what? I don't want to hear it. I don't want to hear
Well, Judge, you're insulting me on the record in front of my client, and I believe that I should be able to defend myself.
You can do that later. You can make your record later, but you've been insulting me the entire trial. So, blatantly, taking your headphones off, arguing with me, storming out, coming late intentionally if you don't like my rulings. So, quite frankly, this has been long overdue. So please be seated. You can receive the evidence. I will receive the evidence. And then you can put whatever you want on the record at the end. Go ahead.
2B, which is Nicholas Cruz Henderson records, episode 1.
I'm sorry?
Episode 1, Henderson records for Nicholas Cruz.
2V?
I'm sorry, 2B is in Victor.
Is there any objection to 2V as in Victor?
Sorry, what was that again, please?
2B.
I can't read.
Oh, Henderson Behavioral Health, episode 1.
That's fine.
Without objection, 2V will be received as 93.
2W, Henderson records, episode 2.
Is there any objection to 2W?
No, Your Honor.
2W without objection will be received as 90.
This judge has been the very definition of grace, especially with the defense team constantly trying to test her limits with courtroom stunts, delays, and borderline disrespect. While the attorneys kept pushing the boundaries of courtroom manners, she handled it all with professionalism.
Let him
At the
finish.
end of the day,
Let him finish.
If we're gonna open the door on that,
Mr.
no,
Brooks.
since he want to make a record and not be.
Daryl Brooks was arrested after driving his SUV into a Christmas parade in Waukesha, killing 6 and injuring many more. But instead of showing remorse, he fired his lawyers and chose to represent himself, responding to the court with nothing but disrespect and cold arrogance.
Without having that letter.
So
The state has the ability to question you about that, or question this witness, and to look at the veracity of what your claims are here. So, I may take an early lunch, and if that's in your cell, then you can go get it and bring it. But without that letter, I'm not allowing this line of questioning. Do you have the letter with you in court?
I just said no. How
Okay.
many times I gotta say the same thing on record?
You know, sometimes, sir, I don't hear what you say because you interrupt me so much or you answer quietly. And I'm taking notes and I'm focused on probably a dozen things at the same time.
But if I say something under my breath, everybody seems to hear it. Everybody seems to hear
In
that
a
just
quiet
fine.
courtroom,
And everybody
yes, we can
assumes-
hear it very
and
clearly.
everybody assumes that it has to be disparaging. Or,
Once again, you're doing this tactic.
Because
you try to
it's not a
go
tactic,
off
it's
of
facts.
what we're talking
It's
about
facts.
to some other reason.
it's facts.
to
Because
some
I
other
find it
thing.
hard to believe that
I'm going to
all
let
of
the
a sudden
state.
nobody hears what I say.
I'm going to let the
Come on,
state
man,
make
stop.
a record of why they
Stop.
believe it's objectionable, because I haven't let them do that. I've given you multiple opportunities to tell me why you
So
believe
I
it's.
didn't get these pictures from nobody else. Why was
The
somebody
record will
else
reflect you have 2 pictures that you believe were from this witness.
that I know is from?
No, that you believe.
That I know.
All right, I'll ask the state their position on all of this.
My position, Your Honor, is that these pictures, first of all, should not be admissible. 1, because of a discovery violation. We've never seen them before. 2, because we have reason to believe that he did not get them from Erica Patterson. He is on a jail phone call talking to his mother, Dawn Woods, about Dawn Woods sending these photographs to him. Now,
that's a lie. I object to
Let
that.
the state make their argument without interruption, sir.
That's a lie, though.
3, I believe that these photographs are designed to make a suggestion to the jury that Erica Patterson is a bad mom. I think that is what the defendant is trying to do. And if we're going to go down that road, then we would be forced to counter that claim. First of all, it doesn't make her an incredible witness, if it's even true. And second of all, if we go down that road, we would be forced to counter that claim by pointing out that not only does the defendant not live with the child in question, he doesn't live with any of the other children that he has. He impregnated Erica Patterson when she was a minor in Nevada, and for doing so, he was convicted of statutory sexual seduction, pled guilty in March of 2007 to that felony offense, and is a sex offender on the registry as a result. So if there's any causation that would lead to Erica Patterson being a bad mom, Mr. Brooks has a direct role in that causation.
And that's
furthermore,
I object to that.
I'm not
because
done.
that's a lie.
Let him
Because at the end of the day,
Let
if
him
we
finish,
gonna open the door
Mr.
on that, no,
Brooks.
since he want to make a record and not be accurate, so let's be accurate all on the record. Since you think you know so much,
Once
so
again,
we can
Mr.
open the
Brooks
door
is
on.
being
We can
loud,
open the door on how old she told me she was when we met.
interrupting.
We can ask that question
He is
too. Then
over the
Did you
top
ask that?
animated
Do you
right
know
now.
that?
Mr.
The prosecution was clearly fed up. Brooks kept whining about problems he was warned about the moment he ditched his lawyers. He chose chaos, then had the audacity to blame the system for it.
Mr. Brooks, I'm ordering you to sit down and to let the state
No,
finish.
no, I'm not going to sit here and let somebody be inaccurate on the record and lie on the record.
Right. Under Illinois versus Allen, I've warned him repeatedly. He's being removed from the courtroom. And you know what? Let me dial that back. We're just going to take an early lunch, 1 hour. We'll be back. And unless he brings that letter and he can show it is inadmissible, she will not be questioned. And under 906.11, I will declare the cross-examination closed. Thank you. We're in recess. 1 hour.
Get your facts straight. So let's open the door on all of it then, so we can get all of it on the record. Since you think you know so much. Did you know she said she was 18 when I met her? Did you know that?
Daryl was kicked out of the courtroom after repeatedly interrupting the judge and refusing to let anyone else speak. Even during the trial, he brought nothing but ego and chaos. In the end, the jury found him guilty on multiple counts. As always, thanks for watching. If you enjoyed this wild ride, don't forget to hit that like button and subscribe. Let us know about your favorite moment in the comments below. We'll see you in the next one.